Morning, everybody. My name's Andy Ledger. I'm the business development consultant for Data Privacy Advisory Service. It's always a bit daunting talking out into the void. I don't quite know how many people are actually out there. The only people that I know are here are Tash and Rowenna, and obviously Jordan doing the slides in the background. Today, Tash and Rowenna are going to have a conversation, I think, about lawful basis. I'll be handing them over to them shortly. Just to introduce them, if we can go to the next slide, please. So Tash offers DPO as a service. She's the founder of Privacy Space. She's worked in data management for 30 years and has been on exciting assignments such as anti-money laundering in the past before moving on to the even more glamorous world of data protection. Rowenna has just quickly described herself as a professional data protection nerd. Her words, not mine. And originally she said she was in it for fun and profit, but then revised to say fun and non-profit. So if I can just take you through some slides quickly just now about the housekeeping. If you've got questions, please use the chat function, and Tash and Rowenna will try and answer them during the session. I'll also be keeping a lookout for any. We won't be able to answer all questions at the time, but we'll be able to come back at a later date and answer them. The session's been recorded, so if you miss something, you can watch it later. We're going to last for about an hour, and also DPAS will be sending out post-webinar materials recording, including a feedback survey. We really do value your feedback about the webinar itself, but also about suggestions for future subjects and so on. So without further ado, is that all my slides? Jordan, I think if you want to move on to the next slide. Okay, that's certainly not my area of business. So I'm going to hand over to these two experts. Thank you very much for your time and really look forward to this.
Brilliant. Thank you so much, Andy. Yeah, lawful basis, big topic. I thought we'd start with just nailing down what we mean by lawful basis. So apologies to the experts in the room, you already know this stuff, but if we have any data protection beginners or new enthusiasts joining us, probably worth setting out what all this is. So GDPR Article 5 says, personal data shall be processed lawfully, fairly, and in a transparent manner. And then GDPR Article 6 goes into what lawfully means. And that's processing shall be lawful only if and to the extent that at least one of the following applies, then sets out some conditions. I don't know about you, Tash, but I encounter a lot of misunderstanding about what lawful basis is, what it means, what it's for. Do you experience that in your work?
I do as well, and I also interchangeably, which I know is wrong, use lawful basis for Article 9 and 10 as well, where I know that actually technically they are conditions for processing, which is slightly different, but I still think falls under the lawful bit, but technically is not a lawful basis. So yes, the amount of times I see a privacy notice as well that says things like, our lawful basis is that we have a lawful basis. You're like, no, you're not getting this. It's not.
So lawful basis is essentially a list of circumstances under which it is okay to process personal data. Annie, could we have the next slide, please? And those conditions, lawful basis, those good reasons for having personal data and doing stuff with it are when the data subject, that's the person the data is relating to, has given their consent. Warning, conditions apply. When there's a contract with the data subject. When
there's very important, can't stress one enough, with the data subject, not with their company, with the data subject themselves.
That's right. That's why I've got that in bold, because the data subject themselves actually has to be a party to the contract. They've got to be one of the people agreeing to its terms. When there's a law that says you have to do something which requires you to process personal data, when somebody somebody's vital interests, the stuff that's keeping them alive, requires personal data to be processed. Excuse me, I've got germs. When the organization is acting in the public interest according to a requirement set out in law or as a public authority, or the favorite one, when there is legitimate interests in the processing which do not unduly burden the rights and freedoms of the data subject. That last bit tends to get a bit lost. We'll go into that a bit more in a bit.
And I think I would love it if this list was written so that consent was always at the bottom. And the reason for that is when you look at the way the GDPR is written, for the other 5, processing must be necessary. That's really important. I'm sorry, I'm probably talking over slides. You know what I'm like for slides. This probably comes up in about 3 slides time. But for me, that's so important because these other 5, the processing must be necessary. You must need that data. And if you don't need the data, your only option is consent, then with conditions applying. So I try and say, keep consent in your back pocket almost, because it's the one you're least likely to use. Because if you don't need it, do you really need to use it?
Absolutely. And yep, I have definitely put that on the slides, but it's so important that it's worth saying over and over and over again. Consent should be at the bottom of the list. So what we're going to do now is just quickly chat through the various requirements for each lawful basis and poke around at some good practice, some bad practice, some gotchas, some do's and don'ts. So we're going to start with contract because, as Tash and I both agree, consent should be last. So put that to the last. We're going to look at the contract with the data subject. So Andy, can we have the next slide, please? Oh, before we get in with the contract, yes, there was something I wanted to say. A lot of the time, people say things like, oh, we have legitimate interests for this data, which makes no sense because the lawful basis is for processing of data, not having the data itself, although storing the data might be one of the processing activities. But it's for the reason you're doing stuff with the data. And the reason for that is that you might have the same piece of data, processing it for a multitude of different purposes under different lawful bases, like someone's email address, for example. And if you attach the lawful basis to the processing, that means, if necessary, you can stop that processing while still continue your other processing. But if you try and attach it to the data, you get yourself in a right pickle because you end up with a situation where you both have to have the data and can't have the data at once. So don't think about the data, think about the processing you're doing with the data when it comes to lawful basis. And I think that's a really important point that often goes under the radar. What do you
And I
reckon,
think,
Tash?
yeah, because I always find it really odd that your ROPA technically doesn't have to contain the lawful basis. And yet it is the most logical place to put it for people to understand how lawful basis works. Because when you have it against the processing activity in your ROPA, you know, for example, I'll give the example you gave, the email address, it might be needed because you've collected it as part of the contract, but it also may well be needed or not, they might want to use it for marketing purposes. And that's going to be 2 completely different lawful bases. And they can object to it for marketing, but they can't object to it for a contract. And so I just find it astonishing that the ROPA doesn't need to contain the lawful basis. I put it in every single one because I think it makes sense. But I just find that strange because they've done that. It would be a lot easier to understand.
I think so too. And again, this comes back to something data protection professionals say a lot, that the law is a floor, not a ceiling. The law says the minimum amount you have to do, but there's nothing to stop you and loads of benefit to doing more than the bare minimum. And so keeping track of what lawful basis, what processing activities are being carried out under in the ROPA it's just common sense, really. Yes, it's a little bit extra work up front, but the amount of effort and hassle it saves you in the long run is enormous.
Yeah, agree.
Another thing I find when talking about lawful basis to people who aren't professional data protection nerds is that it often tends to overshadow the purpose of the processing. People get so hung up on what's the lawful basis that they haven't necessarily sat down and thought about what the purpose is. Now, the purpose, 9 times out of 10, will point you straight at the appropriate lawful basis. So figuring out what lawful basis should apply starts with saying,
Here's what I found.
what is the purpose of this processing? And important also not to confuse processing activities with purpose. Sending emails is not a purpose. Sending marketing emails is not a purpose. Nobody gets up in the morning and go, my purpose in life is to send marketing. Okay, no, maybe they do. I'm not judging. But that's the sending the email is a processing activity. It's done for the purpose of attracting and retaining customers or donors or stakeholders. So the purpose should point directly at the lawful basis. And if the lawful basis isn't necessarily obvious, it's always worth going back to the purpose and saying, have we been clear enough about this? And a tip I use for getting to the purpose is the toddler approach. It's basically keep asking why until you get to a single clear sentence answer.
Yeah, exactly. We've had a question on the Q&A row, and I don't necessarily want to answer it now, but I do want to ask whoever's written it just to explain what their acronyms mean. So if you wouldn't mind just going in and explaining your acronyms, we'll come back to the question afterwards. Thank you.
Cool. Thank you. Now make the Q&A chat window go away. Yes, thank you. As Tash and I have said, leave consent to last. If you're looking at a possible choice between consent and legitimate interests, leave that idea completely to last as well. Work through the other lawful bases and make sure they don't apply before getting to consent or legitimate interest. And the reason for that mainly is that if you go down one route of applying a lawful basis, it's really hard to back out and still continue to be processing lawfully and fairly.
Yeah.
So yeah, don't back yourself into a corner until you're absolutely sure of your ground.
And that's actually a good segue into the question asked on the Q&A. So I know the Q&A question is about special category data as opposed to personal data generally, which is what we're mainly covering, but it's a perfect example of why you don't just jump to consent. So the question here is about using substantial public interest for special category data. Again, those derogations within the Data Protection Act are things you should be looking for before consent. So when you're talking about vulnerable customers, for example, I'm going to go into a little bit of rabbit hole here and just bear with me a second. For those of you that are familiar, the Texas approach with the FCA talks about using explicit consent with vulnerable customers. No. It also has a line that says, unless data protection says otherwise, and that's where data protection trumps them. Because data protection allows you to look at public interest and then derogations about not reasonably being able to get consent, therefore you don't get consent. And you can't always get consent from vulnerable customers. So it's the same thought process. So sort of trying to answer that question, but without derailing it, it's the same thought process. Keep consent last. There are other options. And as Rowenna says, most of the time those other options will be contract and things like that. You know, your last two choices are going to be legitimate interest and consent.
Yeah, absolutely. And if all this sounds horrific, terrifying, and insanely complicated, then bear in mind that you don't have to work it out for yourself. You can always hire a data protection expert to do it for you.
Yeah.
And the last one, show you're working. This is really important. So data protection is not physics. It isn't a set of rules that always apply in certain circumstances. There's one right answer and all the other answers are wrong. It's not a question of working out mathematically what the right answer is. Data protection is about people, so it's messy, it's changeable, there are different opinions, different approaches. And that means there's always going to be somebody who disagrees with your answer. That doesn't necessarily make your answer wrong, but it does make it really important to keep a record of how you arrived at that answer. So showing your working, detailing your thought process, preferably with, references to the materials you used, like the GDPR. Yeah, showing your working is really important. Now, if by some stretch of the imagination the ICO were to actually take an interest in enforcing on lawful basis, they wouldn't punish you for coming to a different conclusion from the one that they think is correct. If you can show your working, show a good faith attempt to really get it right, then they might tell you to do it differently, but they won't punish you for having done it the way you've done it. However, if you can't show any kind of thought process leading up to your the answer that they think is wrong, then you're more likely to get the side eye from them and possibly even a strongly worded letter.
Yeah, totally agree. Always have a defensible position behind you, always.
Okay, so with those handy tips on selecting a lawful basis done, let's have the first lawful basis slide, contract or negotiations for a contract. Thank you. So there are two parts to this lawful basis, and it covered two lots of scenarios. So when the processing is necessary, that really important word, necessary to fulfill the terms of a contract with the data subject, or necessary to conduct negotiations for a contract with the data subject. Now, it's very easy to say, oh, well, we're going to have a contract with you, therefore everything we want to do to put that in place is necessary. But that's not enough. You've got to back that up. Where in the contract does it say this? What is the contract? And in fact, Meta tried this as their long battle to defend their egregious intrusive surveillance advertising. What they did was they put it in the contract so that they could say it was a term of the contract. And the court said, nah, you can't do that. So don't try and do that. So you need to know which part of the contract says makes the processing necessary. And there are some possible gotchas there. So if the contract itself contains unfair terms, then you can't use those terms to legitimize processing. Meta. If the data subject isn't a party to the contract, say the employer is, then you can't use this lawful basis. And if the processing isn't actually necessary, so perhaps there are other ways, less intrusive, more minimizing ways to achieve the same ends, or if the contract basis is being applied far too broadly across processing that doesn't have anything to do with it, then you may find that this doesn't hold up when it comes, if it should come to an investigation or an inquiry or an incident.
So an example of where we use this one quite a lot in everyday life with our clients is someone they want a job with the company. Okay, if someone is looking for a job with you, they're a candidate, they are looking to enter into a contract with you, which means some of the processing can be used as contract. They're looking to enter into an employment contract with you, but not all. It doesn't mean you can go ahead and record all the calls you have with them or the interviews. So there is always going to be some things that you need to know. You need to know the details of their CV. You need to know whether they are going to be suitable to have that contract, to have the job. But that doesn't mean everything is going to be covered by it. So in Europa, I would expect some of the recruitment work to be under contract. Others, I absolutely wouldn't. And that goes back to what we were saying earlier. You have to look at it process by process. You can't just say, as I know some government entities do, that this whole thing, recruitment is contract. Not all of it is, because there is things that you gather during that process that really that process is not necessary. So just bear that in mind.
Yeah, absolutely. There's again coming back to the first point, understanding what the contract says, what it means, and what it's asking is key to determining whether or not you can apply this lawful basis. So there's a lot of thinking to be done there. Okay, contract. May we have the next slide, please, Andy? The legal obligation. So this one's fun. There's a law, either written out as a statute or secondary legislation, or set by precedent in common law, don't forget about that, that makes the processing of this personal data necessary to comply with the law. So the first question there is, which law? Which law are we talking about? There's a lot of myth floating around out there about law, not just data protection law, health and safety law, anti-money laundering law, you name a law, and there'll be a dozen myths about what it requires. So the first point of call for applying this lawful basis is, be really clear about what law and why. It's impossible.
We're going to muddy the waters, right? Going to muddy the waters. The ICO has said that the FCA handbook can be considered under legal obligation, which is quite interesting because, I certainly wouldn't have thought of those as being law, but if there's something that has to be complied with to make you regulated, then they believe the FCA handbook falls under this, which is quite useful when you are then considering the data that you're collecting in order for you to comply with the FCA regulations.
Yeah, absolutely. And I would also point to statutory codes of practice as well. They don't have, they're not legislation themselves, but if they set out how the law is to be complied with and are, referenced in court proceedings, then they have a similar level of weight. And again, law is the floor, not the ceiling. So if you end up doing better than the bare minimum that you can get away with, then that's no bad thing.
Yeah. Again, be careful, because if the law is anti-money laundering, the anti-money laundering regulations say you need to be checking these people for this transaction. It doesn't say you need to also collect this data and this data and this data. So you've got to make sure you are being proportional to the risk that applies to your company in order for it to apply under legal obligation.
And proportionate to the rights and freedoms of the data subject.
Yeah, yeah.
Which is a part that often goes unnoticed. So couple of examples of a processing which is required by law is keeping accident reports in a workplace for health and safety law. Keeping tax records of how much you've paid your employees and what tax codes they're on, or perhaps if you're a charity, keeping gift aid records for claiming gift aid from donations. I mean, there is also I saw in the chat somebody brought up the right to work stuff, and yes, absolutely, you've got to be careful with that one. There's a problem with the right to work stuff in that the Home Office demands that you process excessively in order to make their lives easier. So if you follow the letter of the law, you make the check that the person has the right to work by checking their documents, and then you record the outcome of the check and you get rid of the documents. However, the Home Office wants you to keep copies of the documents. Because they don't trust you, I don't know, whatever. So there is a tension there between what government policy demands and what the law actually says. 99 times out of 100, any organisation is going to go with, well, we'll do what the Home Office says because they're more likely to cause us a problem than the ICO. But it does mean that looking very closely about what processing is necessary and doing proportionate processing to that is important. So if you were to keep those identity documents to keep the Home Office off your back, they would need to be in a very secure location with access controlled and logged, and there would need to be processes in place to make sure that they were not reused for any other purpose. So you essentially can almost consider them equivalent to under the right to restriction. Just because you've got them doesn't mean you can use them, especially if you shouldn't really have them in the first place, but you're just trying to stay on the right side of the anti-immigration crowd. Alrighty, on to the next slide, please. Vital interests. Have you ever actually come across a real world scenario in which this applied, Tash?
No, the only one we ever really use as examples is if you are dying on the floor from a peanut allergy, it's absolutely fine for me to tell the ambulance people that you have a peanut allergy, but I think some of the COVID pandemic stuff that they did invoke some of the vital interest for the data sharing of this. But obviously that doesn't apply anymore. But yeah, very, very not needed this in reality.
Yeah, so the vital interest, vital from Latin, vita, life. Yeah, it means this is life or death. Um, but that's not always easy to determine. So does the risk have to be immediate? So, okay, yes, if somebody's, lying on the floor, turning blue and clutching their throat and gasping, then it's okay to communicate or to look up or disclose the fact that they have an allergy that sent them into anaphylaxis. But does that also extend to keeping on record the fact that a person does have a deadly allergy in order to put in appropriate controls to make sure they're not exposed to that allergy? So how proximate does the risk have to be? I think on balance, you probably be better off acting in a way that keeps people alive than worrying about the scope of vital interests. But it is worth thinking about because this sort of thing can come up. Also, for example, if somebody is heading over to their ex's house with a loaded gun stating an intent to do away with them, then data protection law allows you under vital interest to do what you need to do in terms of data processing to protect the intended target.
And welfare checks as well. Potentially, you have to think it's got to be based on, a lot of the vital interest stuff. It's weird because most of the times I think of vital interest, it's going to be using special category data as well. So that always muddies it up a little bit. But if you think of something like a welfare check, you are using their address. You didn't expect to be using their address to do a welfare check. You expected to be using it to send their pay slip or something like that, So that's using it under vital interest. But you also then need to consider, if they were able for you to give consent, would they have given consent? If they can't, then it's probably going to have to fall under vital interest. I can see a couple of questions about this. One, can you contact, what is it with acronyms today? Next of kin. Yes, potentially. Think very, very hard about that though. I'm only saying potentially there. You could, again, I think that as welfare check, but I wouldn't be contacting next of kin. I would tend to go to the police for welfare checks before I'd go for next of kin.
Also, be very careful with next of kin. It has a very specific meaning in law. It means the person who inherits from that person's estate or who collects their belongings after they die in medical or public authority care. Emergency contact is the appropriate phrase to use. And this tangles a lot of people up because they put next of kin on a form and then they're like, oh, but all my next of kins are estranged. I'm not speaking to them. The person to call is actually somebody who's not related to me. What do I do? So just for the sake of clarity, unless you are dealing with estate law or, say hospice care, stay away from the phrase next of kin, use emergency contact.
Yeah, exactly. I cannot stress that enough. And you'll find a lot of HR systems naturally have next of kin written in there, and there's not a lot you can do about it. But yeah, try and colloquially use emergency contact instead for exactly that reason.
I would be tempted to challenge those HR systems as not being supportive of the accuracy, adequacy, and relevance.
Oh, Ro, I have bigger issues with the HR systems than just that one. I can cope with that one.
I know. I feel your pain. I've been there.
Good question from Claire there. If you collect medical data in case you need to use it in an emergency situation, do you collect it under consent and then show under vital interest? So I consider the collection of it just in case to be a different lawful basis from the use of it under an emergency situation.
Mhm.
So
Two
yes, I'm
different
not saying
processing
yes to you
activities.
having the correct, I'm not necessarily collecting under consent to start with. There may be a different lawful basis for collecting it in the first place, but definitely a different lawful basis for the collection of just in case versus actual using it.
So this goes back to what we were saying earlier about lawful basis being attached to processing activities, not the data itself. So you've got two different processing activities for two different purposes there, and therefore you will have two different lawful bases. Other possible gotchas. How definite does the potential impact to somebody's life have to be? You know, is a possibility enough? Is likelihood enough? Does it have to be probable, or can you only process the data if somebody certainly will die unless you do? Those are questions that there is no right answer for. This goes back to the show you're working. So whatever conclusion you come to, you need to have your reasoning documented so that you can justify it in the event that you have to. Also bear in mind that one of the purpose of data protection is to uphold and protect people's fundamental rights and freedoms. One of those fundamental rights is the right to life. You've got to be alive for data protection law to apply. Therefore, if it's between preserving life and ticking data protection boxes, you really ought to go with the keeping people alive option.
Yeah, probably want to move slides. I think that's on the next slide from memory. Oh, maybe it's not. Okay, it's gone. Sorry, I'm lying. I thought you'd written that down because I remember reading that. I think that's really good.
It's in the notes.
Ah, that'll be why.
Yes, my secret notes that nobody else can see. um, yeah, so vital interests, you know, if it comes to a choice between processing personal data or watching somebody die, process the personal data. You can sort the rest out later, for goodness sake. If you're looking at vital interests for a future possibility, then you need to do quite a bit more work to make sure that you're on solid ground there. I did once have somebody say to me that safeguarding reporting should fall under vital interests because it's a quality of life issue. And I don't know that I agree with that, but I think there were some valid points made there. Again, if that's the route you're taking, document, document, document.
And don't forget with vital interest, if they do die, GDPR no longer applies.
There's an ethics question in there too.
Yeah.
Would an organization rather face complaints from a live data subject about how their personal data has been processed, or in the event of a dead data subject but with no liability, would that be preferable? That's a good ethics litmus test.
Yeah.
You know, ideally, the organization would keep the person alive. But you know how business thinking goes when it comes to risk to the organization. It may actually be lower risk to the organization to let the person die, which is
Scary, isn't it?
we have data protection law that says you've got to do stuff to look after people, even if it's not profitable.
Yeah.
So here we are on public interest stroke authority, and looks like my notes didn't come through in the not notes, the gotchas didn't come through on this one, or I missed them, so I'm an idiot. Apologies for that. This is when processing is necessary. Yeah, I've messed up this
Yeah,
slide.
the slide's gone to pot. Okay, we'll have to wing this one. We're good at that.
I made loads of notes. What's going on here? So when the processing is necessary in order to fulfill a task in the public interest as set out in law, or the duties of a public authority, brackets as defined in freedom of information legislation. So necessary is the first thing, you know. If it's something that all organizations do, payroll, supply chain management, then you can't use public interest because it's not specific. But things like social care services, HMRC sending out government gateway activation codes to freelancers who are scrambling to do their tax returns. Universities making grants to individual researchers, highways agency logging reported potholes. If it's something that the public or a public authority only does because they are the public authority, then the processing can fall under this. The
I
processing
have
that is
a really good one here, Ro. So this is
Oh,
where you
yeah,
see the
yeah.
difference between you being the ethics and me being the commercial head here, because this is going to be really interesting. So we come up against a lot of situations where we're working with a civ tech or a med tech or something like that for the purposes of creating a tool, potentially using AI, not necessarily, that is going to help doctors or it's going to help schools perform their public task. The school will absolutely be using public task for this, okay? But for the creation of that tool, we're often having to be joint controllers. And so what you find is that the tech company is also having to use a public task lawful basis, which they wouldn't normally use, because when you speak to the ICO, they said you can't, joint controllers shouldn't have two different lawful bases, because part of joint controllership is the same processes on the same data, converging activities. And I find that one really, really interesting. And it's something I haven't quite got my head around. At the moment, we just show our workings, but I don't feel that's right.
I'm not sure I agree with the ICO's stance there because, again, the same data set can be processed in multiple ways for multiple purposes under multiple lawful bases, even if one of those sets of processing is done under joint controllership.
Yes, so if you look at the one that is done under joint controllership, that's where they have to be converging, therefore potentially the same lawful basis.
Yep. Yeah, that's an interesting tension there. Yeah, I I haven't come across that one, so thank you very much.
Yeah,
That's one to gnaw on in the
yeah.
dark hours of the night.
And we tend to do that when we're doing DPIAs and we're looking at implementing something like this. We'll have stage 0, which is the creation of the technology that sits behind it. And then when we actually implement that technology for the public service, for the doctors, whatever like that, and we are not doing anything else on it, we're a SaaS, we're just a processor. So we step away from a lawful basis. But it's one of those circumstances where I find that the law hasn't really caught up with the way the world is working at the moment. And
I'm
put so much
intrigued though.
thought into it.
Why would the both organizations not go with legitimate interests for the development of the tool, then public task by the public authority for use of the tool?
Potentially they could, but what we find is public authorities don't like the idea of using legitimate interest. Whether they should or not, that's up to their DPO to decide. But we end up in this really interesting stance where, it's a bit Goliath and Daniel, and we sort of have
David.
to go. Sorry, oh my God, it's been a long week. Thank you. We end up having to go with whatever is the majority lawful basis, as it were, because we don't really get a say. But I do see public authorities don't like using legitimate interest. And I think it's because of the stance that this should rarely be used by public authorities, which I think is in the ICO wording as well. And it's like, well, actually, no, sometimes they can use legitimate interest if it's not definitely part of their task. But it's that working out, is it definitely part of their task or not, that I think causes the problem.
It's really interesting because I've encountered a lot of public authorities, usually councils, who just insist on using legitimate interest for everything, whether it applies or not. So yeah, I guess that would depend on the degree of internal, in-house knowledge and expertise that the organization has access to. Yeah, so it's
Question on here, question on the Q&A. One thing I find confusing, oh, it's moved, okay, is when you're processing on behalf of a public authority, would the appropriate basis still be public interest if not directly public authority? If you're
not your
processing on their
problem.
behalf, you're a processor. You do not need a lawful basis if you're a processor. Really, really important.
Yeah, as if you're determining lawful basis, you are not a processor. So yeah, stay out of that lane if you don't want the hassle.
Exactly.
So the public interest and authority, again, with the sort of duality of public-private partnerships, this can also apply to disclosures to public authorities. It's worth bearing in mind that a legal gateway, a law that says you are allowed to do this, is not the same as an obligation to do it. Just because you can doesn't mean you should. So you have a duty to make safeguarding alerts. If you're, regulated professions have to report safeguarding concerns to public authorities. So that's an obligation. Whereas assisting a council's private contractor to chase parking fines, you've got some discretion there.
I'm going to really drill on this because this is my real bugbear. I work with an organisation that gets, well, when I first started working with them, probably got 5 or 6 police requests a week. Okay, so they were requests for data. And what was happening is the police realised we had a big data set. And they were literally using us like the yellow pages. And before I came on board, they'd be like, oh, God, no, the police said so. We have to give it to them. I'm like, whoa, 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 no, we don't. And even now, so we're now down to about 2 a month, which is much better because they've got used to the fact that we say no most of the time. So what we always say is, regardless of what the police have said on their form, because they will always try and push us. And we've had the same with HMRC as well, of saying, you absolutely have to give us this. And it's like, we really don't, unless there is a court order. What we have to do is make sure we are comfortable that we have a lawful basis to do it. And most of the time, that lawful basis will be legitimate interest, without moving on to that, but only if the balancing test applies. And if we can't make that balancing test add up, we are not giving the police the data, which is really, I find really difficult from an ethical perspective sometimes, because I want to help the police. I want to catch the baddies. But equally, this isn't why the data was given to us as an organisation. It wasn't there purely for the police to use it as the yellow pages.
Yeah.
So in
Also,
that circumstance, just because you can share with a public authority, the police or whoever, doesn't mean you have to, and it doesn't mean it's always right to do it. You have to make sure you have a lawful basis to do so.
yeah, if the police have to have the information, they'll get a warrant.
Exactly.
If there's a warrant, hand it over. That's a legal obligation.
Yeah.
If they can't get a warrant, then there is a question as to whether or not they do in fact need that data, or whether it's convenient for them to have,
Yeah.
which is not the same thing at all.
Yeah.
This is especially important when looking at certain vulnerable populations, particularly people with mental health issues who do not tend to fare well at the hands of the police. People of ethnic minorities, cultural minorities. These are people who may need extra protection from the police just because of the way human beings and societies arrange themselves.
Yeah, my default answer to any police request, my default is no unless. And I think that takes a lot of getting used to. It certainly for the companies that I was advising was a real like, what, really? It's like, yeah, sorry. We had one situation where there was a request because they had found, got to work out how I word this carefully. They had found a portion of a membership card, for want of a better way of saying it, like a club card, but not a club card, because I don't work with Tesco's. Like a club card, they'd found the portion of it, and they wanted to identify who that portion of the club card belonged to, because it was with a whole load of stuff that had been fly tipped. Now, there was something in the news not long before that I'd read, where some lovely old granny was fined thousands for fly tipping when actually her wheelie bin had blown over and a bill had fallen out that had her name and address on. And I was just like, there is no way on earth we are going to tell you who that membership card belonged to, because we don't know that it's going to be used as ethically as it could. That just doesn't feel right. If it doesn't sit right, then no.
Also, there are, scammers who will offer to take your rubbish away and then just fly tip it.
Exactly.
So
Although that does stay your responsibility, unfortunately, but even so, it's like, no.
Correlation causation fallacy there. Just because somebody's data was found somewhere does not mean they were the person that put it there.
So quick answer on that one about the the form signed by an appropriate senior officer as of PACE, blah, 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 blah. That is the lawful basis for the police to have that data once they have received it. It is not your lawful basis to give it to them. Honestly, I cannot stress that enough, because the police will try and bombard you with this all the time of filling in this beautiful form, you know, and they're saying, and you don't need to tell the data subject. That's great. We don't need to tell the data subject because they've ticked that. That's lovely. But everything is about their lawful basis once they get it. Okay,
Yeah.
doesn't mean you have to give it to them without your own lawful basis for sharing. Okay, I'll get off my high horse now and let us carry on.
So that is really, really important. Okay, so let's skip, seeing as we've touched on it a few times already, let's go on to legitimate interests. Here we go.
I'm just going to interrupt you there, Rowenna. Just to say to both of you, I know you're deeply embroiled in this really interesting conversation. We're coming into the last 15 minutes of this, really, just to give you a bit of sense of of timings there and so on.
Okay, so I'm going to, I mean, at the moment, you know, data use and access bill in the news, things are going to change. There will be automatic legitimate interests for particular purpose for processing. I have my own opinions about that. I'm sure you can tell what they are from my face. However, the automatically a legitimate interest only applies if the processing is conducted according to the data protection principles, rights and obligations. If you're not doing the processing according to the principles, rights and obligations, then you can't say, oh, well, it's a legitimate interest and it's on the list of things that are okay to do under legitimate interests. It is not a gateway for non-compliant processing. It's mostly intended to avoid everybody having to duplicate the same effort in things that are commonly done. So the processing has to be lawful, fair and transparent for specific legitimate purposes, etc., etc. So for security, for example, checking IT systems accesses for warning signs, yeah, legitimate interest. But installing webcam capture and keylogging software on all employee computers in case somebody is doing wrong, that you cannot justify as being an automatic lawful basis for security purposes, because it is not fair and it's not proportionate and it's not necessary. So you might think the data use and access bill is going to make life easier and just allow you to kind of tick a box and not have to think about legitimate interests. That is not the case. You still need to do the thinking about how the processing is going to be carried out and what the processing is. So yeah, marketing, for example, suggesting a donation amount based on a person's postcode because people in that postcode tend to be really well heeled. Fine, great. Buying marketing lists of dubious provenance or breaching PECA. No, those do not automatically become okay just because they fit under marketing. Marketing is a recognised legitimate interest. Some of these things can just be done under the DAUB. Hobby horse.
Yeah, I find legitimate interest a really interesting one. You know, almost every client I work with, LIAs, legitimate interest assessments, are the bottom of our list of priorities to get done, but only because when we've gone through the roper in the first place, we've done an LIA in our head straight away. You know, when you've done enough of these, you know when something is going to pass a balancing test. And this is, again, I keep coming back to the police requests. These are where they're the ones that nearly always fail that test the second I read them, because I'm like, no, just no, that just feels wrong. And if it feels wrong, it's never going to pass an LIA. You know, so yes, you do need to back these things up with a written LIA, and you know, we're working through backlogs of them at the moment, and ideally you should do them ahead of time. Realistically, I'm not sure that every company does, but at least go through that thought process beforehand. And if it smells funny, it is funny and it's not legitimate interest.
Which brings us nicely onto the next slide. About legitimate interests, good practice, bad practice, ugly practice. So the sniff test, as you were just saying there, Tash, you know, if it smells funny, it's probably funny. If you have to jump through hoops and use the words technically not illegal, then you can't get it through under legitimate interest. So what is good is it passes the sniff test. It's been designed inclusively, not just for the top demographic tier of society. So think about impacts on minority groups and vulnerable people. If the impacts have been looked at critically, not as a post hoc, yes, this is all fine because we're going to do it anyway, but a really rigorous and disciplined look at the opposite point of view. And again, as always, show you're working. The bad is putting liability risk to the organization as the focus of the balancing test and just completely forgetting about the impact of the rights and freedoms of the individual. So this is the interesting one because ethics, law, and risk are not the same things. You start conversation about ethics and you hear, well, that's too hard. What do we do for compliance? You tell them what they do for compliance. You hear that's too hard. Let's talk about risk to the organization. So be very careful where those lines lie. Cosmetic compliance, where you just write up an LIA as a kind of justification for the thing that you're doing anyway and have no intention of changing. That's not great. Unnecessary and excessive processing bundled into the LIA in order to legitimize it. And what is interesting is not the same as what is in somebody's interests, which is something that the media keeps coming up against in terms of defamation law. Just because it's interesting does not mean you have a legitimate interest in pursuing it. And there are a couple of ugly non-essential cookies cannot be set under legitimate interests. God damn it, because cookie setting comes under PECA, not the GDPR. You've got to satisfy PECA first. And if the cookie is not essential, then you have to get consent. An unfair or unreasonable processing. So processing which is known to be flawed, discriminatory, inimical to people's rights and freedoms, difficult to predict the outcomes of, that really can't pass an LIA.
The interesting thing I found with LIAs, and this is from when I did the Maastricht course, and I've not seen this written down as something you absolutely have to do, but it was something they insisted on in the Maastricht course. If you have someone who objects to legitimate interest, you shouldn't just be providing your generic LIA that you did. You should look at their case individually and do an additional LIA for them. I mean, if you're not going to delete the data, I'm thinking most cases when someone genuinely objects, there probably is a good reason you probably would delete their data. But if you look at an example of it's a completely legitimate thing, and Rowenna may disagree with me, for senior employees to have their photos on your website, okay? That's legitimate. However, if one of those employees has just left an abusive relationship, they may contact you and say, can you please take this down? That is an objection. You can't just present them your LIA that you did for all senior staff because it doesn't relate to their particular situation. Okay, so I mean, a good person again would just go, yeah, absolutely, we'll take it down, no problem. But if you were being argued against, you would do an LIA for the reasons they've given you as to why their rights and freedoms are now at risk as a result of your actions. So I generally say if you're having an objection to anything that isn't direct marketing, but a genuine objection to something where you've chosen a legitimate interest, revisit your LIA for that particular situation.
Absolutely. Couldn't agree more. Okay, so we quickly hop on to consent.
In 5 minutes, go on, whiz through, Ro.
So,
I'll listen to this one.
Must be informed, freely given, specific, unambiguous, evidenced, and revocable. That's not a buffet, a pick and mix. All of those conditions have to apply for consent to be valid under the GDPR. Okay, moving on to the next slide. Consent versus legitimate interests. Which to use? So as a rule of thumb, go for legitimate interests when the processing is routine, mundane, everyday stuff that everybody does all the time, lawfully, fairly, transparently, etc. where choice is impractical. So you can perhaps respond to objections, but you've got so many data subjects that getting all of their consent is just bonkers, and it would say ruin their experience or be adverse to their interests as perhaps an interested prospective customer. When you're very confident that most of the people you ask won't say no. If you think people will say no, then you have to go for consent. And yeah, low impact processing, mundane stuff. Go for consent if the processing is unexpected or unusual. If you have a sneaking suspicion that half or more of the people you ask will say no, and if the processing is high impact. So if the processing is necessary for something important, usually it'll already have been covered off by one of the other lawful bases. So this is for stuff that, it shouldn't be that big a deal. Bear in mind, we're looking just Article 6 here. This is not about special category data. That's a whole different webinar on its own. So yeah, that's the rule of thumb when you're trying to decide. Legitimate interest is not the easy alternative to consent. If it's done properly, in good faith, it's just as much work, just different work. What do you reckon, Tash?
I'm good. I'm actually answering some of the questions on the thing, so you carry
nice
on.
one. Good skills. Okay. So yeah, we've all, data protection people tend to encounter situations where an organization will say, well, if we ask them, they'll say no. So can we do it under legitimate interests? The answer is no. If you think they'll say no, then you have to ask, because it's just not fair to do it any other way, and you will probably fail your balancing test. So
And you can't switch just because they said no to consent, which is a lot of the questions coming up about the cookie banners are very similar to that. Slightly different rule, but it's very similar. If they said no to consent, you can't switch the lawful basis to legitimate interest. You stick with your original lawful basis.
No means no unless they come back of their own volition and change it to a yes. Yeah, absolutely.
A question the other way, could we switch from LI to consent later? I can't think when you would, but yes, you can. The way that I tend to do anything like that is in my ROPA, it would be this process up to this date, lawful basis equals legitimate interest, and they have the right to object. This process after this date was based on consent, and they can withdraw consent at any time. And we actually write that in the privacy notice, because the ICA is really big on don't ever change your lawful basis just because you had the wrong one. Do you know what? Sometimes you have to, particularly when you go into a company as a DPO for the first time, you look at it and go, oh my God, why did the last DPO say this? Because we always disagree with each other, because it is a little bit open to interpretation. So I have had situations where we've had to say, we did rely on consent for this. Do you know what? For existing customers, we now don't rely on consent. We now rely on legitimate interest from anything gathered from this date onwards, or something like that.
I would also say that being that the ICO doesn't enforce anything other than the security principle and regulation 22 of PECA, not even 22, 21, you should be more concerned with a court's interpretation, because a court will impose sanctions. A court will pay less attention to the ICO's potentially wrong guidance than the legislative text. The ICO has several times had to change its guidance after the courts have disagreed with their interpretation. So don't pay too much attention to what the ICO says if it seems to conflict with the actual text of law or already established case law.
Or just no sense at all.
Oh, just common sense. Yeah, there is that too.
No, you clearly do not understand my question.
So that brings us to thank you, and we've still got quite a few questions in the chat. I reckon we can probably tackle those by email.
Yeah, I think if it's possible, and I've been really impressed with the fact that you've both been multitasking and answering questions and juggling all sorts of stuff. That was really impressive. I think the solution to this is, obviously, we've had a lot of people on this webinar today, to invite you back again at some point later on this year, if you're both up for it.
Definitely.
Really want to say thank you very much for your time and your enthusiasm and passion for this subject. The big concern that we always have is number of questions, because if we don't get questions, we feel like people aren't engaging. That's certainly not been a problem today. We've had, I think, we would possibly say more than enough questions, and it would be great if we could get some responses back to that. Just to reiterate, we will be sending out a recording of this, so if you haven't been able to catch all of it, or if you want to share it with colleagues, that's great. We've got another webinar rather, coming up at a date to be agreed soon around subject access requests. And just again to say thanks to Tash and Rowenna. Thank you very much for your time and energy. And I think we'll be signing off from Gooding Towers here now. Thank you very much.
Everyone. Thank you. Thanks, Ro.
Thank you.
Thank you. No,
Thanks,
thanks.
Andy. Thanks you
Thank
all.
you. Bye. Bye.